Hello, everybody. We're going to give people a little bit more time to get signed in before we begin. It's 1 minute out from launch, and we'll give everybody probably 2 minutes, and then we'll get going. Welcome, everybody. For those of you who are just joining us, we're going to give those signing in on the hour just a little bit more time to get their technology working with them. So we'll start in a little bit under a minute. All right, we'll go ahead and get started. Welcome. My name is Erin Inman. I'm the director of the National Traffic Law Center with the National District Attorneys Association, and I'm pleased to welcome you to our webinar today, The Confrontation Clause and Its Impact on Traffic Safety, a primer. We have 3 very talented and knowledgeable presenters joining us today. We're going to start off with Judge Kate Huffman, who is an Ohio Second Appellate District Judge and the American Bar Association National Judicial Fellow. She is going to start by giving us some background information about the Confrontation Clause and how it's been interpreted in the Supreme Court and how it applies to traffic safety cases. Then we will be joined by Dina Ryerson, who is the Oregon Traffic Safety Resource Prosecutor. She's going to give us a prosecutor's perspective and discuss some of what's been happening in Oregon as a consequence of the Smith versus Arizona case. And then finally, we will have Dr. Saber Jones, the National Highway Traffic Safety Association Regional Toxicologist Liaison for Region 3, talk about some of the impact or some of the difficulties that the labs are facing. That will be basically an hour, we anticipate, each panelist taking about 20 minutes. And then we're saving about 15 minutes in the end for questions. If you do have questions, please feel free to drop them into the chat. I also wanted to thank the National Highway Traffic Safety Administration, NHTSA, for funding this project and this webinar, and several of us who work on these types of cases. One more housekeeping item before we get started. We have CLE approval, continuing legal education, pending in the states of Illinois, Montana, Tennessee, and Virginia. If you could email Hannah Garby, HGARBEE, at ndaajustice.org, and I will repeat that in a little bit. Email her your information and bar number if you're from one of those states, if you would like CLE credit. And she will work with you to make sure that that happens. Again, it's HGARBEE at ndaajustice.org for any of those states. If you are from a different state and you can self-report, you can go out to the platform where you registered for this course and get all of the materials. And I see that Hannah dropped her email in this chat, so you can get that there. Go out to the platform where you registered for this webinar and you can get the materials so that you can also self-report. At the end of this webinar, there will be an automatic certificate generated. Again, if you have difficulty getting CLE credit or you need assistance with that in any way, please feel free to reach out to Hannah. And with that, Judge Huffman, I will turn it over to you.
Thanks very much. We're going to start out with just a basic discussion about the Confrontation Clause and its source, and then some interpretations by the Supreme Court. If you'll advance the slide, please. Oh, sorry, right there is good. So the Sixth Amendment states that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. So it is applicable in criminal cases only. And the source or the purpose behind the Sixth Amendment was to address what many colonists believed were abuses in the English legal system, particularly in the 16th and 17th century, where individuals could be prosecuted and convicted based upon the affidavits of individuals who were not available at trial. Actually, availability was not an issue. They simply were not present at trial. And gave testimony through those affidavits that meant that the defendant did not have a right to cross-examine the affiant. And colonists were well aware of this English practice, had been subjected to prosecutions based upon the English practice of utilizing affidavits only. And it was an abuse that the colonists were not willing to continue. And so the opposition to that type of testimony based upon affidavit and no opportunity to cross-examination was well rooted in sort of colonial ideas of fairness when the Bill of Rights was enacted. So this was not something new that was contained within the Bill of Rights. Next slide, please. So let's think about prior to Crawford. So I started practicing in 1990. Did just a little bit of criminal work, but I will tell you that never in that time did the issue of the Confrontation Clause arise. And by that I mean it was never something on my radar. In watching trials, I never saw that issue presented. To me, this seems to be somewhat of a forgotten constitutional right prior to the time Crawford was decided. Pre-Crawford, the Confrontation Clause analysis was really rooted in a hearsay analysis, in that if a witness was unavailable to testify at trial, then the court engaged in an analysis of the reliability or the trustworthiness of the testimony. Again, very similar to an evaluation of really any hearsay issue. The Confrontation Clause was almost centered pre-Crawford on, was there a hearsay exception that allowed this testimony, which then meant there was a high degree of judicial discretion, thus making any decision by a trial court allowing in evidence that likely today would be a violation of the Confrontation Clause. This is an abuse of discretion that is very difficult to overturn. So let's then talk about hearsay, because hearsay is still very much a concern when it comes to the Confrontation Clause. If you'll advance the slides, please. So let's just talk about some basics about hearsay. The definition of hearsay, and it may be slightly different in your jurisdiction, but generally speaking, the definition is that hearsay is a statement other than one made by the declarant while testifying at trial. So something said outside of the courtroom, offered into evidence to prove the truth of the matter asserted. So there's really two requirements we're going to focus on. Was a statement made by a declarant, by a person? And was the statement offered into evidence to prove that the substance of the statement was true? Next slide, please. There are many things or many reasons why a statement would be offered other than for the truth of the matter. And I just have a few examples here. to show the effect on the listener. So whether a listener was surprised, they already knew the essence of the statement, to explain the actions of a witness. So this is what I believed, and therefore I did something as a result. To explain investigative actions. This is the one I would say most often that in a criminal case where the evidence will come in that it might appear at first blush to be hearsay, but instead of proving it for the truth of the matter, instead it is to explain maybe why an officer went to a certain location, why an officer looked for a piece of evidence, whatever that might have be. And then something else is very important that demonstrates that a statement is not for the truth of the matter is it might provide context to other actions, other things that occurred. In reviewing whether something is for the truth of the matter, oftentimes courts will look at then what was the purpose of the statement. Instead of saying, well, it's not for the truth of the matter, tell me then what it is for, so I can determine if it isn't for the truth of the matter. Next slide, please. And again, we can see what courts often will look at in determining whether a statement was not for the truth of the matter. These are just some of the potential reasons why a statement would be offered and it would not be for the truth of the matter. Whether somebody was present, whether a particular person knew something. An example might be a witness says, he knew I had a gun. How did he know you had a gun? Because I told him once, or I heard Mary say that Joe has a gun. All right, so it can prove knowledge. Motive, so the purpose of the testimony may be a motive. Again, sort of the classic example being, I was told that my spouse was having an affair, and again, that's not to prove that the spouse is having an affair, but instead a motive for a shooting, by way of example. Opportunity, and then absence of mistake, meaning a witness knew or had heard something, and therefore some other action did not result from a mistake. Next slide, please. And those are also can be found, if we look in Evidence Rule 404, if you're a state that follows, relatively speaking, the federal rules, look at Evidence Rule 404 for some guidance on statements that are not hearsay or not to prove the truth of the matter. So we know pre-Crawford, the analysis that courts engaged in was a hearsay one. Is it hearsay? Well, if it's not offered for the truth of the matter, then it's not hearsay. So we never go through that analysis. If it is hearsay and the witness is not available, then is there a hearsay exception that would allow the testimony in? That's pre-Crawford. Then in 2004, in many ways, in my opinion, the criminal world was kind of rocked by Crawford versus Washington. And in Crawford, Mr. Crawford was on trial for domestic violence. He allegedly stabbed his wife. His wife had made a number of statements to law enforcement, but she refused to testify. So during trial, a police officer took the stand, testified, basically said, this is what wife said. Now, under the pre-Crawford analysis, she's unavailable because she refuses to testify. And is there a hearsay exception that allows the statements in? It could be excited utterance. And my recollection is it was admitted on an excited utterance basis. Well, then the case winds its way up to the US Supreme Court. And, the court was confronted with, no pun intended, the Confrontation Clause. And instead of this being a hearsay analysis, is it an analysis based on confrontation, because for Mr. Crawford, if the only analysis had been hearsay, it never would have gotten to the Supreme Court. It would never, none of us would know anything about Mr. Crawford if we had stopped the analysis at hearsay, because there was no question that there was a hearsay exception. So instead, the court looked at, did a separate constitutional right have some implication, that being the confrontation clause. So if you'll advance the slide, please. While she's doing that, I do want to comment, if you've not read Crawford, I highly recommend that you read it carefully, along with the other cases since Crawford. Clark versus Ohio is another one, or it might, sometimes it's under Ohio versus Clark, I think. Another one that is really important, but just to have a good understanding of confrontation clause, it's really important to follow this line of cases since 2004 that really has changed how, not only how we view the confrontation clause, but how it impacts criminal prosecution. So in Crawford, the court sort of started out with the basis of the confrontation clause bars the admission at trial of an absent witness's testimony generally. But then the court went and sort of limited what was subject to the confrontation clause and what was still subject to a hearsay analysis. And the court said, if a statement is testimonial in nature, then that is when we confront the confrontation clause. If a statement is not testimonial in nature, then we use a traditional hearsay analysis. Well, then that left us with asking the court, what the heck is testimonial? And the court defined it, although without criticizing the Supreme Court, I would say maybe didn't define it in a way that was really easy to understand. The court defined testimonial as one where the purpose of the statement is to be used at trial. So is to be used at a prosecution, which leaves us with, what are the other statements? What is the purpose of the other statements? Motive, etc. All right, if we could go on then. So that was 2004. 2006, we had the Supreme Court developing its primary purpose test, meaning, well, how do we determine testimonial statements? And the court said, if the primary purpose of the statement is to enable the police to assist in an ongoing emergency, it is not a testimonial statement. Which sort of leads us to the opposite conclusion. A testimonial statement is one where there is no longer an ongoing emergency, and the primary purpose instead of the statement is to use at a later prosecution. That was more fully defined in 2011 by Michigan versus Bryan, both of these by the US Supreme Court. So if we look at it, it became, whether you call it the primary purpose test or the ongoing emergency test, it really became, what is the purpose of this statement? Is it to assist the police in apprehending someone that is at large, that may be of danger to others? Or is it, okay, the emergency has been resolved, the victim or the witness is now safe, and now we have moved from ongoing emergency to the investigative stage. And in essence, it's the investigative stage where we can run afoul of the confrontation clause if the statement is made at that time and the witness does not testify. Next slide, please. A classic example of something that is not testimonial, where a victim calls 911 and says, my husband just stabbed me. This would be Mrs. Crawford. Get somebody here right away. He ran out of the house. I'm afraid he'll come back and hurt me. We have an ongoing emergency here. We don't know where he is. We don't know that she's safe. And she has made this statement not, most courts would say the statement was not made for purposes of future prosecution, but instead for purposes of somebody assisting her and to help make her safe. So again, here the primary purpose is not investigative, but instead to address an ongoing emergency. Next slide, please. This is actually from a case decided by the Ohio Supreme Court recently, where the police get on the scene within a minute or so of a shooting. And I'm going to call her just girlfriend. Girlfriend is with her new boyfriend. He's been shot by, she says, former boyfriend. She makes a number of statements to the police, and they're really just trying to calm her down. She's very hysterical. And so some of the things that they're saying to her is really in an effort to calm her down. She makes a number of statements, even before the medics arrive, and she's continually asking, is he dead? Is he alive? Is he going to be okay? And she's constantly looking around. This is in a body cam video, constantly looking around, you know, is he here? Is he around? Is he going to hurt me? Little did she know, or the officer know, that other police officers had stopped him for a traffic offense, the shooter. And they were hearing on the radio about this shooting that's close by. So they just kind of held him and said, hey, we're just trying to figure out who you are, what's going on. Did not have him in handcuffs or anything. And the Ohio Supreme Court said, you know, just because he was in custody, she and the officer who were talking to her did not know the ongoing emergency had been resolved, that she was safe, that he was in custody, and therefore that the statements that she made until that officer and she knew he was in custody did not violate the Confrontation Clause, because they believed that there continued to be an ongoing emergency. Next slide, please. So really the analysis is there an ongoing emergency? If so, the statements are not testimonial in nature, generally speaking. If the ongoing emergency has been resolved, or the primary purpose of the questions is not about the ongoing emergency, but about prior conduct, other issues, then those statements are testimonial. So then we get to, if you'll move to the next slide, please. Then we move to some cases that bring us to where we are today. Two cases, well, actually three, but two we'll talk about on this slide. Melendez-Diaz was really the first Confrontation Clause case that looked at what happens when, when we have a lab test. And in that particular case, there was an analyst who prepared a certificate of analysis as to lab test results, did not testify. And the court said the defendant had a Confrontation Clause right to cross-examine the lab analyst, that the certificate, that this lab test result was insufficient in and of itself to satisfy confrontation. And then Bull Cumming versus New Mexico comes along a couple years later, and the court says one lab analyst cannot testify about the results from another lab analyst. In other words, you can't have a substitute analyst simply come in and kind of read the report. Then next slide, please. Just a year later in Williams versus Illinois, court took a little bit of a different turn in looking at reports of analysts. And the court said an analyst can predicate an expert conclusion under the rules of evidence on somebody else's statements. Remember, experts can rely on hearsay. And the court in Williams versus Illinois said the absent analyst, their statements were not introduced for the truth of the matter, therefore not hearsay, but instead to explain the basis for the testifying analyst's expert opinion. This decision was abrogated by Smith versus Arizona, but you can see we have this progression of cases by the Supreme Court where creating a great deal of confusion about the test results, particularly toxicology test results, from analysts. Then we get in 2024, next slide, please, to Smith versus Arizona. And from my perspective, this is solely my perspective, this case rocked the world of really forensics in many respects in toxicology. And Dina Ryerson is going to talk about this more in just a moment, but Smith said, where an expert conveys an absent analyst's statements, meaning results in the testifying expert's opinion, the statements are for the truth of the matter. And therefore, they come in, or excuse me, they are subject to confrontation clause analysis. In other words, this is a complete reversal from the 2012 case of Williams versus Arizona, or Williams versus Illinois, where the court said the statements aren't for the truth of the matter. They're a predicate to an expert opinion. So now we have this circumstance where, is there any ability of a lab analyst who did not perform the tests to testify about anything involving the tests? So I'll pass it on then to Dina now.
Okay. Hopefully, can everyone hear me okay? Erin, can you give me a sound check really quick?
You're good, Dina.
Okay. So, hi everyone, Dina Ryerson. I'm the traffic safety resource prosecutor for the state of Oregon, one of two. Amy Seeley is also a traffic safety resource prosecutor for Oregon. I'm just gonna talk super fast because I have a lot of slides. And I know we'll have a chance for questions, so we're going to leave time for that. Just getting a little bit more into the details of the Smith versus Arizona case, it's important to know the type of testing that was done and what the court's ruling was to then understand the arguments that are going to come after that. So in this case, it was a more like a drug chemistry test where the analyst tested the actual substances, determined them to be meth and cannabis. There was some notes involved, typed out notes, and then a signed report. That analyst was not available to testify for trial, so a substitute analyst reviewed the work, reviewed the notes of RAST, reviewed the data, and then came to what we called as an independent opinion, or what's what the state argued about each substance that was identified. And both parties agreed in that case that the confrontation claim only succeeded if the statements that RAST made, meaning the notes and the rest of it, came into evidence for their truths. Next slide. And so obviously the defense argued that RAST statements were subject to the confrontation clause, that they were hearsay. And the state argued that no, the statements made in that case came into evidence, not for their truth, but to show that this other person who came to testify, it was a basis of their opinion, of this alternate scientist's opinion, and that their opinion was independent. Next slide. The court didn't agree with the state, as we all know now, and said that they basically said this was hearsay. They said the confrontation clause applies to testimonial hearsay and testimonial statements, and bars the introduction of any hearsay that is offered to prove the truth of the matter asserted. And so the Supreme Court needed to determine if the statements made in the Smith versus Arizona case constituted hearsay. As we'll see in a second, they deferred on whether the statements were testimonial. So next slide. So as the judge indicated, the court determined that when an expert decides to convey statements of an absent analyst's work, or any statements made in support of their opinion, that is being offered for the truth of those statements, the truth of the matter asserted, and therefore the confrontation clause was violated. And they said, well, we're not going to determine, it's going to go back to Arizona to determine if the testimonial argument was forfeited by Arizona, or if not, to prove that the statements were or were not testimonial. And so I believe in talking to Beth Barnes, who's the traffic safety resource prosecutor for Arizona, that they declined to proceed further on that case. Her information is at the end of my presentation too, and she's a great resource in this area. Next slide. So some useful language that came out of the Supreme Court case talked about how experts can testify regarding generally the functions of the lab and maintaining chain of custody, and that will become relevant as we go into post-Smith era. And that they can testify about forensic guidelines, accreditation process, standards, procedures for testing, and the like. There is a section in there on the fact that experts can be asked hypothetical questions. So if you assume some of the out-of-court statements were true, what would follow from it? But they still went on to say that you still have to prove, if it's hearsay, then it's still a problem if you have to prove the truth of the matter asserted with that statement. So something to look into a little bit more. But next slide. So now, just to be clear, the Smith case was about drug chemistry. So the toxicologist tested the actual samples, saw that they were meth, cannabis. There is more implications now in when we're talking about forensic testings. Next slide. So one of the main arguments that we know has also arisen from this is when you have a difference between cradle to grave testing in toxicology versus assembly line testing, where various individuals might put the sample on and do the screening, and that might be a different person than the person who does the confirmation, and then there's various people sorted in through that. And so the question is, and then one person ends up submitting the lab report and the opinion. And so the issue is, can the state present evidence of the toxicology analysis solely through the testimony of the forensic scientist who reviews all the instrument data, and from that review of the instrument data then formulates an independent opinion and issues the final report? So is that the person that can be the person to testify? Or does that also violate the confrontation clause? And so that is one of the biggest questions that the states are dealing with right now. So next slide. And the answer is yes. In many cases, the state's argument is that does not violate the confrontation clause. And so when we consider this, we say, well, the confrontation clause is only triggered by the admission of a witness or testimonial statements made by a non-testifying declarant. And so we have to find out what statements they are. And the defense, and this is important for prosecutors, what statements is the defense saying were made? Okay, so they have to identify, and the court will have to consider exactly which out-of-court statements are at issue to even trigger the confrontation analysis. Next slide. And so the state's argument, and this is, so I'll tell you what happened in Oregon after we go through this. But it was the basis of our state's argument, and I think what prosecutors all over the country should be arguing, at least one of the arguments is that the state is not offering the statements of anyone other than the toxicologist who reviewed all the data and formulated their opinion based on the independent review of that data, and that the report, number two, memorializes the results of their own independent analysis and review of the data, and that their conclusion and opinions are not based on any hearsay statement, but based on personal knowledge of reviewing the data. And therefore, yes, I believe they'll get a copy of the presentation. I just saw a question pop up. Yes. And and I can also send it to anyone who wants it. But I believe you will be getting it. Right, Erin?
That is correct. And I'll go over that a little bit at the end, Dina. Thanks.
Okay. I figured some other people might have the same question, so I thought I'd address it really quick. So then anyway, that the conclusions or opinions are based on personal knowledge of reviewing the data and won't contain hearsay. Next slide. So the first argument of the three that I just listed that is that the state's not offering statements for actual statements from anyone other than the toxicologist witness who's coming to testify. And yes, there are other people that may have handled the sample or engaged in a physical act, but that physical act is not a statement. And that the process of the assembly line testing is that each individual's perform a discrete task, a physical task, but they're not making a statement. And it's not being offered again. There's no statement being offered against the defendant. So that's part one. And then next slide. Then the next part is, okay, so the toxicologist reviews all the data, right? And actually creates a report in reviewing all the data, even though there's other individuals who, started the instrument, that doesn't mean that they made any statements relating to it. So it's important to note and also pointed out in the Smith case that these toxicologists can testify to their personal knowledge of the process and procedures that the labs engage in, and that includes establishing that chain of custody, that those systems have to be put in place to ensure the integrity of the sample and the validity of the testing, and that they look at all the procedures for the testing, and they know that in their own knowledge, and that they go back and look at the instrument data in order to formulate their opinion, and that's all independently done. They can pull the instrument data and review it all and do a comparison of all the stages of the testing in order to prepare that report, and that the state is not intending to admit something that is signed by a different analyst who had not reviewed the data. Next slide. And finally, they give their opinion, again, based on the review of that data, their personal knowledge of the procedures, standards, and systems employed in the testing, and that the state's not offering any statements made by any of the other individuals in the process, and that they're not basing their opinion on a different person's statement. And that was the key thing in the Smith case, is that they were the RAST had written out notes and had independently observed and verified that the substance was what she said it was, and took notes about it. And so when the substitute analyst came in, they reviewed the statements and the notes, and it's the statements in the notes, and then said, okay, well, I've reviewed that all, and I've also looked at the data, and it is what she said it was. That's different here because they're not reviewing any statements made, and they're just reviewing at the instrumentation and the data and developing their own opinion based on their knowledge of the standards and procedures and what happened in that particular case. And that they had every opportunity, the defense has every opportunity to cross-examine the reporting toxicologist, because they're the one that is going to be present. Okay, we're going to save some questions. Okay, so next slide, so we can get through the rest of this. And so there are situations, the state of Oregon, I know this is gonna it's gonna be crazy, but the state of Oregon just started testing in October drugs in blood. We had sent all our lab results to NMS, who were fantastic. They got our results back to us quickly, but now we're faced with the issue of still getting it through all those cases, and NMS does a assembly line testing, and so this has especially hit Oregon very hard because NMS has 7-8 people who were involved in the testing, and so the question in Oregon was, well, do we need everybody who was involved in the testing process, or can we say they didn't make statements? So in talking to NMS, they said on a rare occasion, or on occasion, there might be a note written in the when the testing was done. So if it is determined that there was a statement or some note made by one of the analysts, what kind of statement is it? Did the toxicologist, look at that statement or rely on that statement to formulate their opinion? And if so, are we going to even offer that statement? Is it, if the state's not going to offer the statement, then, and if the toxicologist couldn't come up with their opinion independent of whatever that statement was, then, those are the kind of distinguishing things you'd want to argue. Next slide. I love this one just because it's a reminder to prosecutors that you make every argument you can if you can make them. So the next slide. All right, so the question, there's the primary purpose argument that if your state has the ability to make it, this is, generally what it will be. In Oregon, we are not allowed to make the primary purpose argument, which is what the judge was talking about. So, any statements, reports, this is what we would argue, notes, records from other people in the chain of testing are not testimonial because their primary purpose for is for like accreditation, licensure, quality improvement, and that their primary purpose is not for the criminal prosecution of the case. And so we'll talk a little bit more about that later, but the argument would be all those other people involved in the assembly line testing, their primary purpose isn't for criminal prosecution. Rather, it is, to ensure that the sample is following, standards and procedures and accuracy and integrity. So next slide. So the question, is it testimonial? So that again, the Supreme Court in the Smith case focused on the primary purpose of the statement. And as I said, how does this, is it made for evidentiary purposes, right? And so they must first identify, is there an out-of-court statement introduced? And given all the relevant circumstances, what is the reason it was made? There's a footnote in the Smith opinion that does talk about, it says the mine run of materials, they called it. Most experts rely on to form an opinion. Books, journals, studies, surveys will raise no confrontation issues, and that they're prepared without any evidentiary value. And so all our labs go through accreditation process and to ensure the accuracy. And so that's, what one of the arguments is, that's more the primary purpose, not for evidentiary purposes. Next slide. So, again, we need to determine why it's made, and the court should be asked to consider all the record keeping activities that analysts engage in. So again, I'm kind of repeating myself. So next slide, so we can get through the rest. So again, the argument is the testing is focused on scientific integrity and not on the courtroom, and when you're dealing with the entire process. And these are the reasons why we would say is the purpose. Next slide. So these are kind of questions you can ask. I have about 3 minutes left. Questions you can ask your forensic scientist. What is the primary purpose of, is your work conducted primarily for a court? Do you test all samples, whether the case is set for trial or not? So there might be other reasons that they do testing. Do you test for other purposes? So like, for example, with NMS, we said, okay, what's their primary purpose? Well, yeah, they do some cases for trial, but they also do workforce drug testing or do testing for civil administrative hearings. And so the argument could be made that these same systems and procedures are done regardless of what the outcome, what the reason for the testimony is. And they can go through, and your witness can talk about all of the accreditation requirements and systems and procedures. And then also determine what your state's legal analysis is prior to Smith on what constitutes, the primary purpose. In Oregon, we cannot argue that. And it sounds like my understanding from my counterparts is that there are some states that preclude the primary purpose argument and some states that don't. So if you have it in your toolbox, great. Next slide. Um, okay, next slide so we can finish up here. Some things to take away. If you've already testified, or if the person's already testified or they were deposed, the confrontation doesn't apply like was discussed earlier. If any possibility that you can have one analyst do all the testing, we do that in Oregon now. Because, and we've always done cradle to grave, but especially now because we've had a case that came out, State versus Weiderman. And now just not too long ago, and they basically said we need every single person involved in the testing. We're appealing that to our Oregon Supreme Court. And that's something that we have to deal with. We just had a manslaughter case happen a week or two ago, and they had to fly out 7 or 8 witnesses from NMS, which let's just say was not a cheap thing for the travel costs and the testimony costs, well over $15,000. So we are appealing that to our Supreme Court. My understanding from Aaron is that there have not been many cases, if any, that have come out analyzing Smith. I know we have, and I would recommend not following Oregon. And so also working with your prosecutors. I know I'm at 12:45. Next slide. So some quick takeaways. Are you going to determine if it's testimonial? What is and what is not testimonial? Make sure you're working with your TSRPs and prosecutors. There's already briefing done on this. I know the TSRPs have the briefing from Oregon. And keep any unused samples. So we have had to now retest a bunch of samples. So if you have an exigency sample versus a warrant draw or something like that, we hope to have extra blood. So if we have to retest anything, but you have to understand that comes with issues, which we'll find out. And so keeping up on the developments of the law obviously is important. And if you can proceed, and I'm done right now really quick, but if you can proceed without toxicology, it's just like you had a refusal case, for a breath test, is there some admissions made or some drugs found in the car? And I think that takes me to the end.
All right, so next it's me. Thank you so much, Dina. Honestly, after your presentation, I don't know if you need me, but I'm here. I'm Saber Jones, and I am going to provide the toxicologist perspective on the impact of the confrontation clause. So just very quickly as an overview, I'm going to take you through how the majority of our toxicology labs across the United States handle casework. I'm going to talk about what the impact of calling all of the individuals who might touch that casework might have on our toxicology labs, and leave with some thinking about some balanced alternatives and some final thoughts. Next slide. So the way in which our toxicology labs structure the workflow is really to maintain an efficient and a valid scientific approach to laboratory operations. And as we heard from Dina, many of the things that we do is to ensure that we have reliability in our casework. So it really comes down to sort of our quality management systems within our laboratories, that we know that the individuals doing the testing are qualified, that our instruments are working properly, and more. And we can really structure this into like 3 distinct processes. Pre-analytical, the analytical process, and post-analytical process that we have to do to meet our policies and procedures of our labs or our accreditation requirements. Next slide. So regardless of where the lab is housed, whether it's a standalone toxicology lab or a toxicology lab that's a part of a bigger crime laboratory system, there is going to be a mechanism in which the sample comes into the laboratory and an evidence control. And those individuals that are involved in that process may not do anything else other than document the receipt of the evidence and send it on to the laboratory that's appropriate for the analysis that's being requested. Next slide. So when we look at our laboratory workflow, a lot of our labs, and although hearing from Dina and considering a change in that or going to a cradle to grave approach, the reason why we do what we do is to really ensure that we can get through our casework in an efficient process. Now, regardless of the lab, typically they are going to start with some type of alcohol testing. And for our labs that do comprehensive testing, they are then going to move into drug testing for the detection of other impairing substances. Next slide. So when we think about drug testing, it has several layers. Next slide. The first being screening. So this is going to give us our presumptive identification of what might be in that sample relevant to the case that we're working on. And it's going to be kind of a combination of approaches. For some labs, it's going to be immunoassay. For other labs, it's going to be more of a chromatography and mass spectrometry approach, or a combination of that. Next slide. But regardless of how the samples are being screened in the laboratory, any of those presumptive results that they are going to end up putting on that report have to be confirmed. And so again, like in the screening, it'll typically be a combination of different methods. And we do structure our methods in the lab based on how things are extracted and then what sort of drugs or drug classes we're looking at. And the reason why we do that is that we can actually batch our samples in an analytical run and be able to test multiple cases at a time. It just lends for a more effective approach to drug testing. Next slide. Now, regardless of the process, whether you're just testing out for alcohol or you're doing comprehensive testing, every single piece of data has to be reviewed. Typically, it may be the person who's actually doing the extraction and analysis, or it could be somebody else within the laboratory. Next. And then finally, those results come together by a person who is going to be preparing that final toxicology results. So when we look at this entire process, regardless of the size of the lab, even those labs that may only have 1 or 2 people, more than one person is typically always going to be involved. Next slide, please. So again, for our toxicologists and our toxicology data, we are relying on the data that our instruments are producing. We're not only looking at the results for our case samples, we're also looking at other data that we run, such as calibration curves that we use to establish the concentration we're determining in that case. We're also looking at the data itself, like chromatography and mass spectral data. We're unlike some of the other more subjective forensic disciplines that might be doing comparisons and things of that nature, because we are looking at data output. And you heard from Dina, you might have a person who's putting the samples on the instrument and other people who are reviewing that data. We're not relying on color changes. We're not reading any lines. It's all data. And so regardless if it's the person who's initially involved in that particular method or the person who's looking at the data, we would be all looking at the same information. Next slide, please. So when we think about the impact that the Confrontation Clause in Smith v. Arizona will have on our toxicologists and our toxicology labs, when you're calling all the individuals who may touch that particular case, you're pulling people off of casework, and that will result in increases to backlogs. It is going to reduce lab throughput, and it will impact other investigations. That's just the reality, because it's going to take time for the toxicologist to prepare to go and testify, to actually make the travel arrangements, be there, and then get back to the laboratory. Next slide. So because, as Dina had mentioned, the things that we do in the laboratory, following set procedures and treating each case the same way to ensure scientific integrity and standardization of testing, you're going to have redundancy of testimony because we structure our sample preparation and our methods and our data analysis in very standard ways. So you will have redundant testimony. This can be overwhelming, right? Because you're going to hear the same things over and over again. Whereas the primary analyst, the person who's looking at all the data, who's signing the report, who's saying, these are the results that we have, they might be in a better position to give more informative testimony. Next slide, please. And as Dina mentioned, and when she said 15,000, I was shocked, but not completely surprised, because it is very expensive, right? It's going to be, when you're calling everyone who's touched a case, that's more subpoenas, that's more travel time, and that's more time in court. Even in a state or a government funded laboratory, and you're not calling in, say, somebody from out of state, there is still that amount of time it takes them to prepare to get to court and to be out of the laboratory. And so for our government funded laboratories, this is going to be a strain on resources, and that's just the reality. And it's going to be a strain on the prosecution and defense budgets. Next slide, please. So when it comes to testimony and to be able to provide information that the judge and juries need to have in making a determination about a particular case, it really comes down to effective communication. Redundant testimony, although it can help you learn things, it may not be the most effective approach. Our testimony really does need to be informative and meaningful. And so, yeah, if that analyst has information that's going to help in that determination, they should be there. But maybe the person who's just preparing the sample for analysis, maybe that's not the person who's going to give you the information you need to make that determination. So testimony really should reflect the analytical judgment, right? We're looking at our data and not just those rogue mechanical steps. Next slide, please. So we do the work that we do in the way that we do it in our toxicology labs because we want to be as efficient as possible. We always hear the joke, we're waiting on toxicology. Well, yeah, you don't want our instant results because you want to know that we're doing what we're supposed to do, so you can rely on our results and they are valid. And so when you take them out of the lab, they're not doing that. And so, yeah, scheduling all those individuals can delay in proceedings and impacting a defendant's and the victim's rights to timely resolution because it takes time to prepare for court. There's also going to be issues. And again, even within states where the lab is located a bit further away from the court, you're going to have individuals who are having to travel to court. And so that's going to take time and it might have other challenges. Next slide, please. Now, I've heard from multiple labs. I get the pleasure of serving about 14 states here in the United States. And so when we talk about their approach with the Confrontation Clause in Smith v. Arizona, some laboratories are taking the reanalysis approach. And that is fine, but you just have to understand that there will be some challenges with that approach. Now, first of all, it's storage. Typically, there's always going to be delays from when that report goes out to when the case is scheduled to be heard, right? And so the sample itself, and they are biological samples, and just like the human body, as it begins to break down after death, a biological sample is also going to break down as well. Storage of those samples can be in the refrigerator, it can be in a freezer, depending on the capacity of the lab, or if the laboratory does not have long-term storage capacity for extended periods of times, they might have a policy where the sample gets sent back to the agency that has requested the testing. Now, regardless of where that happens, when a sample is, say, stored in a freezer and we bring it back out and we have to reanalyze that sample, it has to go through processes like freeze-thaw cycles where the sample itself might begin to break down and we might see changes from our initial results to that reanalysis. And sometimes it's the sample itself, but other times it's the molecule, the drug itself, and having analyte instability. And it's just really dependent on the sample and the molecule or the drug that you're analyzing. The concentration can go up, it can go down, it can remain the same. But there's going to be issues where we see this, and the individual testifying is going to have the knowledge to be able to explain that to the court and why that might be. There's going to be some other considerations. For example, new drugs or novel psychoactive substances. We're going to have limited information about them. And so when it comes to stability and the effects of long-term storage and reanalysis, we might not have information to sort of share about those. And there's also two preservatives. Now, in our standard DUID kits. They typically come in a gray top tube with potassium oxalate and sodium fluoride. And those are the preservatives and the stabilizers that are there to prevent or slow down some of that degradation. But if you have samples that are collected, say at a hospital, not in a kit, they might not have any tube preservative in there. They might have other preservatives and things that are important for hospital testing and clinical testing, but not for our toxicology testing. And so that too can impact our results for reanalysis, and you might see differences. And whether it's before that sample comes to the lab or when that sample gets sent back to the requesting agency and then say sent back for reanalysis, a lab can't control sort of how that sample is stored in those situations. And so again, it's just something to be aware of and consider when reanalysis is the approach that the lab is going to take. Next slide. So we have to really think about some balanced alternatives. We really want to make sure the testimony that the toxicologist is giving is going to be meaningful and provide the information needed for that particular case. And so typically, as Dina mentioned, if the person signing off on that report, whether it's from the initial analysis or a reevaluation of the data, because that analyst is no longer there, that person is looking at all the data and coming to their conclusion on that particular case. They're having the same information available at that point in time as was available previously. Courts just have to weigh the necessity of having each analyst's testimony and if that makes sense, right? And although it seems to be not the most popular approach, if you do need everybody, if there could be a consideration for remote testimony, it seems like that might be in the legal perspective that my toxicology mind doesn't quite get, and why that's not always going to work out. But technology is something that we have now that we can do. And maybe if you do need everybody involved, maybe that is a way to sort of balance the extreme cost of calling everybody and the travel cost with getting the information that's needed. Next slide. So in conclusion, we want to make sure that defendants and victims have their time in court, and they do get to cross-examine the witnesses and the individuals who are touching their evidence. But we want to make sure that it's meaningful, right? It's getting information that's helpful for the determination of that case. We also want to maintain the efficiency of laboratory operations, and as well as the scientific integrity of what happens when you pull all the analysts out of the laboratory. A focused, role-based approach, it's helpful in preserving the fairness, but also the function of the laboratory, because an empty laboratory isn't serving anybody. It's certainly not going to help us in the prosecution and the evaluation of these cases. Next slide, please. Okay, I think I got us back on time and plenty of time for questions. So I'll turn it back over to Erin. I just want to huge thanks to Erin and Kim and Hannah and everybody for the opportunity to get to join the webinar.
Thank you, Sabra and Judge Huffman and Dina. That was wonderful. A couple of items before we dive into questions. If you do have a question, please feel free to drop it in the chat, and Kim Brown, our senior attorney at the National Traffic Law Center, will be going through those and asking our panelists those questions in just a moment. I did want everybody to know that if you go back in the chat a little bit, Kim dropped a link to an article in our Between the Lines newsletter that talks about Smith versus Arizona. So that's available for you. It's free out on the internet. Feel free to share that with anybody that you'd like. This webinar has been recorded and will be available at NDAA on our learning platform. So if you are listening to this as a pre-recorded webinar and you're interested in CLEAS, please reach out to us and we'll work with you in that capacity. If you're listening live today, feel free to share it with any of your colleagues who may be interested. And of course, you can always go back and listen to it again yourself. There were some questions about whether or not the slides would be available for everybody. Those are available, again, through the platform through which you registered for this course. If you have difficulty accessing any of those materials, please reach out to Hannah Garby. Her email is in the chat, and I'll say it one more time, HGARBEE at ndaajustice.org. Again, we do have CLEs pending in some states, and if you're interested in the CLE, obtaining CLE credit in your state, Hannah is also the person to reach out to about how to go about doing that. Let me make sure that I covered everything. Yes, and with that, Kim, we're ready for questions.
Yes, ma'am. A couple questions. The first one is, would you have the person testifying actually look at and review the actual evidence? For example, the packaging, the tube of blood, the baggie of powder, etc., so they can also testify to the packaging they actually looked at?
So I'm going to jump in really quick on this one. I know the way we argued about this kind of thing is it's all part of the process that the person reviews. So, and chain of custody, right? So, like I know with NMS, this is how, this is the one that related to our argument is they do what's it called? Like a scan, they scan the Sabra, do you want to explain that? I'm not doing a good job of it. You know what I'm saying? So you can they can review all the data that Sabra is about to say and go through the chain of custody, and that's more of a chain of custody issue, and they can say why they know for sure that that sample is the defendant's. And I'm going to just turn it over to Sabra so I don't put.
No, that was great. But yes, so some labs are set up where they have like a barcoded system. And as that little sample moves through the laboratory and different individuals are touching it, they are actually scanning it. And that's that linkage from person to person. And even some labs have gone like a step further where they're actually taking images of what's coming into the laboratory. So they have like a visual representation of what that sample, the condition that sample came in. So yeah.
Thank you.
Barcode was the words I could not come up with. Yes. And one thing to add really quick, one of the participants or one of the attendees is Lynn Howard with Oregon. And she used to work at our crime lab and then was a prosecutor in Oregon. So she's amazing at, so she's the one who actually developed the record on the Weiderman case that came out and did an amazing job. And so a lot of the briefing that comes out of Oregon comes from the Weiderman case. But what she did also do, and what I send to all my prosecutors, if any prosecutors are interested in, so she came from the lab for many years, so she understands the whole thing, better than any prosecutor I've met. And the transcript, the Weiderman transcript, did an amazing, she did an amazing job of going through the barcodes, going through what, the kind of testing and how it was, wasn't like you don't need all these people. So that's another resource. I think Erin may already have the transcript, but if not, I will send it to her for anyone who wants it. But the transcripts are fantastic for prosecutors, and it basically lines them through the kinds of questions that prosecutors can ask to establish all of this. And so that's another resource. And again, hopefully our Supreme Court will will change the conclusion that the court said. But I wanted to throw that out there.
Thanks, Tina, for offering that transcript. There's another question. Many labs keep records of the communication logs between analysts, techs, and even prosecutors, etc., on the cases worked. What, if any, implication do these recorded communications between analysts and techs have on the prosecutor's discovery responsibilities, especially after Smith? Are they witness statements and are they discoverable?
So I know in Oregon, if they ask for the whole packet, they get the whole packet. Like there's nothing that's hidden. And so the question then is, are there statements that the analysts relied on to formulate their opinion? And if that's the case, then the defense needs to identify which statements, and then we would need to, as the state, argue, well, those weren't statements that are relevant to formulate the opinion of the in this case. And so in Oregon, all of it would be discoverable if they're asked, if they ask for the background paperwork.
Yeah, I know that's consistent with several states. Dina, if not something that's discoverable and been deemed discoverable, as a matter of practice, prosecutors will turn that over because they want to avoid not turning over something that may later be deemed as being exculpatory. Because as we know, defense attorneys and defendants may view a piece of evidence differently than a prosecutor does. And we don't want to be in a situation where a case is thrown out because we didn't turn over communication between analysts in this case. Judge Huffman, did you have anything to add?
And then I don't see any other questions, but there's a comment, and this goes back to the conversation about the barcode and the sample.
Yeah, and
The-
this is, not to interrupt you, Kim, this is actually from Lynn Howard, who did
Okay.
the Fetterman case, and so go ahead.
The comment was that the NMS analysts work in a different state and didn't ever touch the evidence, but I still offered the actual blood sample in court so the jury can see the barcode. Okay, there's another question that just came in. The defense answer to the prosecutorial assertion that the primary purpose of non-testifying analysts' lab activities is to meet established standards is that in the particular criminal case at issue, the primary purpose is to analyze the sample for criminal prosecution, and meeting the lab standards is simply the way to achieve that primary purpose. After all, it's called a litigation packet. Thoughts on this defense argument? Dina? Dina, you're on,
Oh,
you have your microphone.
I was saying I knew you were going to ask me on that, but I would also have the other ladies involved in this. I don't have to worry about this because we don't have the primary purpose argument in Oregon, but I definitely see what the defense is saying, which is what other purpose is it? But I think I think what that argument really is talking about is regardless of the reason, or regardless of the reason the testing. So if I'm testing for workplace, safety, if I'm testing for, some other civil thing or whatever it is, these are always the procedures that are put in place to ensure the accuracy and integrity of the sample. And those procedures are not put in place just for criminal prosecution. And so I think that's what the argument would be, because what you're saying is those things that the other analysts are doing are not testimonial in nature, because those procedures are done the same way regardless of the purpose of the testing. So I think that's the gist of the Sabra. I don't know if you have more to add on that.
Right, right. So like the running our controls of, the steps and things that we do to ensure that the methods are working properly. And as you mentioned, other types of testing that don't necessarily are going to end up in a criminal case, right? That we're doing those same things in all of those instances, and they serve a purpose. And sort of how Boris mentioned, it's the way we get to the answer. But yeah.
Well, and also, there is some case law. It's not in this, I haven't seen any in this context, but there is some case law that suggests that there doesn't have to be only one primary purpose. That there can be more than one. I know the word primary makes it sound like it is the penultimate, but there is case law that says that maybe there's more than one purpose for which we could consider the evidence. I did want to make one other comment though on another topic, and that is that if you think that you may have a confrontation clause issue come up in any trial, I think it's really important that you educate the judge, because you don't know what that judge's experience is, whether it's with the confrontation clause in general or specifically with regard to lab testing, et cetera. And so, doing this beforehand, because when you ask a judge to make a decision in the middle of a trial, kind of on the fly, you may not get the right decision. So I just strongly encourage you to bring it up ahead of time, give the judge plenty of time to think about it, give them the authority that supports whichever party's position it might be, but don't wait till the middle of the trial to bring that up.
Yeah, absolutely. That's such a great point to and have pretrial hearings on this. I mean, I know for us, we have to have pretrial hearings to know what witnesses the judge decides that we need. So
Erin, do we have time for one more question?
Yes, please.
How do prosecutors overcome concerns that the substitute analyst has to rely on statements of another analyst regarding if quality control testing is done or what sample was actually tested?
Can I jump in?
Yes, please.
Yeah. So with regard to that, because that is something that we've had to deal with in forensic science for many decades now, right? And that's where it comes down to the documentation, right? The objective evidence of what has occurred to that sample. And so that does come down to some of that information, like the chain of custody and the documentation, and all the data, right? So even though the quality control steps that we put in place, pre-analytical, analytical, and post, so technical, administrative review, running samples more than once, confirming our initial results, all of those things are to ensure that what we've tested for, we know that it's there because we have sort of something backing that up, the data, right? And reanalysis. That's why we do presumptive testing and confirmation, for example. And so to be able to sort of to articulate that, though, in testimonies, understanding the process and making sure the right questions are being asked to the toxicologist about why those quality control and quality assurance steps exist. And it's to ensure that, that data, that whoever is looking at it, whether it's the first person who touched the case or if it's an analyst who's reanalyzing all this data for testimony, that they know what happened with that sample and that everything was working as it should, because that's what we have to do. We have to have that objective evidence to demonstrate that. And it has to be sufficient that an independent person can come to the same conclusion. And that's really, a lab accreditation type of requirement. It's why we've formalized standards in the United States for forensic science for the last decade. But really it does come down that, there should be sufficient detail that somebody outside that lab can come to the same conclusion.
yeah, and I might not be understanding the question, but what's running through my mind is, so if you're just talking, okay, so the phrase substitute analyst, we have to be careful, right? So in the case of NMS doing testing, there's no, I would never say they have an assembly line process and then the one person reviews all the data. To me, that's not a substitute analyst. And so I wouldn't use the phrase substitute analyst in that scenario. But then you have the Smith and distinguish it from Smith, right? But then if you have the Smith case where there was in fact a substitute analyst, did the analyst who testified rely on a particular statement to formulate the opinion? And if the answer is no on that, then that's what we would argue. If there was no statement they relied on to formulate an opinion, now if there is, then Smith fits squarely, and I think we're in trouble. But if there is a substitute analyst in the truest sense of the word, then that's what happened in Smith. When you're dealing with testing like a assembly line, you don't have a substitute analyst because the person who signed the report reviewed all the instrument data. Now, if that person says, no, I had to rely on a statement to formulate my opinion, then that might be a problem. I'm not, yeah, again, I wasn't sure if I was understanding it correctly, but that's how I kind of sorted that out.
And I think, Dina, in our previous conversations, you had mentioned the importance of getting a clear understanding from the defense about what statements they are contesting. Is that right?
That's the most important part. You really have to narrow the issues down. what statements are they actually relying on? Are there statements that, you know, they use to formulate their opinion? That's really what you have to ask yourself. Or is it that, you know, is there a generally looking at statements that, you know, are out there for just generally quality control? Is that going to be the issue? You know, and that's something that they can then testify to, in a, you know, and say, this is part of the procedures, but it has nothing to do with this particular sample. It's just a general process that the lab has to follow. That's not a statement that they need to rely on for their opinion, if that makes sense.
It does. Thank you, Dina. And thank you, Sabra and Judge Huffman. Thank you, everybody, for joining us today. We've come to the end of our time. If you have follow-up questions, if you're having difficulty accessing materials, if you'd like some of those materials from the Weiderman case that Dina mentioned, please reach out to us. We will make sure that if we don't have it, we find it for you, or we'll find the right person to answer your question. We are here to help. And I don't remember, is this QR code? Oh, this is to join NDAA. I thought maybe it sent to resources. At the National Traffic Law Center, we have several resources. We have 26 monographs that are topic specific with regard to traffic safety, everything from how to cross-examine witnesses to drug toxicology for prosecutors. So if there's anything that we can do to help you in your case, or if one of your colleagues who works in an area outside of traffic law needs some help, please let us know. We're here to help prosecutors and our partner stakeholders across the nation. Thank you again for joining us today, and we hope to see you at our next webinar. Bye-bye.